branch. It gives me immense pleasure to welcome you all. I am Ganesh, Chairman of Indo-American Chamber of Commerce, Andhra and Telangana Division. I am also CFO of K. Raheja Group. So, Indian American Chamber of Commerce, Andhra and Telangana is today organizing a webinar series on navigating cross-border business disputes from courts to arbitration and insolvency solutions. Today, we are organizing second webinar on the same subject, International Arbitration for India-related disputes. We are thankful to Chandhiok and Mahajan and Advocates and Solicitors for the support as knowledge partners. Today, along with us, we have Mr. Rahul Narayan, Partner and Head of Dispute Practice, Chandhiok and Mahajan Advocates and Solicitors. Thank you all the members and guests for joining us today. About Rahul, he is the Head of Dispute Resolution Practice, bringing 20 years of experience in the field. He is an advocate on record with the Supreme Court of India since 2012 and he acted as an arbitrator as well. He has represented clients across various courts and tribunals in India and also international arbitrations. His practice focuses on complex litigation and arbitrations, regulatory investigations, white-collar defense, and data protection privacy. He has represented and advised leading private, public, and government companies across various sectors, such as automobiles, aviation and hospitality, banking and finance, consumer durables, IT, pharmaceuticals, renewable energy, oil and gas, shipping and shipbreaking, real estate and construction, telecommunication, media, and broadcasting. He is qualified in 2004 and read for the BCL at the University of Oxford. He is also qualified in England and Wales. He takes part as a panelist, lecturer, or moderator at seminars, roundtables, and conferences covering diverse topics such as legal issues, strategic litigations, cross-border trade, and privacy. He frequently writes for various newspapers and also contributed chapters on books on technology, law, and Constitution of India. About Indo-American Chamber of Commerce, it's a bilateral chamber, synergistic India-US economic engagement. Indo-American Chamber of Commerce, Andhra and Telangana, serve both the states of Andhra and Telangana. We regularly organize seminars or webinars and interactive sessions for our members. We work very closely with the state government for policy formulation, advocacy, and representation of policy issues on behalf of Indian and American companies for trade-related matters. We closely monitor and work with US Consul General Hyderabad on issues related to visas, trade barriers, and other pertinent matters. We facilitate B2B meetings for inbound delegation from USA with industry sectors in India. We also arrange outbound delegations to USA in coordination with our partners in USA and also identify potential buyers, etc. We coordinate meetings with trade development missions for promotion of bilateral trade. ISAC works for different industry sectors and for different business segments through subcommittees like we work with women entrepreneurs, ISCC Women Leader Forum, and young entrepreneurs through ISCC Young Leaders Forum. We have got 12 offices all across India. Members in one location enjoy the same rights and privileges in other cities as well as to avail the benefits. With this, I wish a very productive and fruitful session. So, thank you everyone.
Thank you, sir. Thank you so much.
Yeah, over to you, Mr. Narayan.
Thank you so much, Mr. Ganesh, for this warm introduction. We are very happy to be part of this wonderful association with the Indo-American Chambers of Commerce, and we are very happy to be able to present this issue before you. And we hope that we are able to add value and to increase the knowledge of our respective members. And of course, we are happy to address any issues that you may have in relation to international disputes as a thing. As Mr. Ganesh has so kindly introduced me, I don't need to get into some detail, but I can tell you in a minute or so about our firm. Chandhiok Mahajan is 10 years old. We are a young and dynamic law firm of over 100 people. We have offices across four cities in India. In New Delhi, where I am based, in Hyderabad, in Mumbai, and in Bangalore. And we hope to expand further. We are a full service law firm. We provide services to our clients in a wide variety of fields. And we hope to increase our association with the Indo-American Chambers of Commerce. We already work with them extensively in New Delhi and Bangalore, and of course in Hyderabad as well. This slideshow is basically in one last thing, of course, in relation to international arbitration. We have a great deal of experience in that, in the sense that we frequently act for parties in international arbitrations, and particularly in connection to enforcement of foreign awards in India and Indian awards to be enforced abroad. We act for Indian parties and foreign parties, and we are able to advise a great deal on dispute resolution as well. I have also been an arbitrator in several matters, and I have recently completed a training with the ICC, an advanced arbitrators training, which is meant for people who already act as arbitrators. So I'm also familiar with the modes and mechanisms of the ICC. And of course, a lot of Indian lawyers have also worked a great deal with the SIAC and with other international tribunals, which is the kind of experience we bring forward, and we hope to share some of that in this presentation today. This presentation is entitled International Arbitration in India Related Disputes. It can consist of two kind of things. It is what about international arbitration which could be based in India, or international arbitration which could be based outside of India. We are happy to cover both kind of topics to give a broad overview of what this entails, and what is a good thing for us to do this. Now we come to the key objectives of this presentation. That will be sorry, just one second. Yeah, yeah. We come to the key objectives, which are introduction to international arbitration, the role of courts, the enforcement of arbitral awards in India, key arbitral institutions, and emerging trends. So to start with, what is international arbitration? In our Indian Arbitration and Conciliation Act defines international arbitration means an arbitration relating to disputes arising out of legal relationships, whether contractual or not, considered as commercial under the laws in force in India, and where at least one of the parties is an individual who is a national of or habitually resident in any country other than India, a body corporate that is incorporated in any country other than India, or an association or body of individuals whose central management and control is exercised in any country other than India, and the government of a foreign country. And of course, as we will discuss a little later, two Indian parties can also choose a foreign seat. Now, what is important in this definition is, and again, this is something which is, I think, key to the Indo-American Chambers of Commerce. As India gets deeper and deeper involved in international trade and the international the thoroughfare, the thoroughfare of international trade and commerce, and we are gradually integrating more and more into the world economy. We frequently encounter situations where Indian companies have to interact with foreign companies. This could be as simple as a purchase transaction. You could be purchasing, say, for example, raw materials from China, or you could be exporting from here to the Netherlands, or it could be vice versa. We are part of international chains which could involve transactions in multiple countries. Now, this could mean, of course, on the positive side, this means that we are far more open to foreign influences, and that we are able to generate far more benefit for our people by rapid economic growth, which is entailed because of foreign trade and greater integration. But the slightly negative side of this is also that we are frequently, as Indian parties, are frequently involved in disputes where one of the parties is not an Indian party, and which means that we are often looking at contracts where there is where dispute resolution is outside the country. Now, many times this could also be, of course, foreign courts, where, for example, if you have purchased, say, steel strips from the Philippines, and maybe the agreement says that the courts of Philippines will have jurisdiction over this. In which case, of course, you have to go to the particular courts. But far more frequently, and this is the general international trend, is that we have something called international commercial arbitration as a means to resolve these disputes. Now, arbitration in India has had a long history. We had in 1940, we had the Indian Arbitration Act, and because of international conventions, now several countries, because this is a problem which is not exactly new. There are because of international relations, whether between countries or between people and countries, there has always been a large system of international arbitration. There is the Permanent Court of International Arbitration, which is, I think, more than 100 years old now. And of course, there are various other international tribunals which are set. Now, in the 1930s, there was the Geneva Convention, to ensure that arbitration awards which are passed in one country, in some countries, are also enforceable in other countries. And there was also New York Convention 1957, which also covers arbitration in different countries for processes of enforcement. India is a signatory to both the Geneva and the New York Conventions. Earlier, we had laws specifically to enforce foreign awards, but in 1996, the Comprehensive Arbitration and Conciliation Act deals with both domestic and international arbitrations. Hence, we come to the first part of the definition which we talked about there. That was what is international arbitration, which is defined in Section 2F of the Arbitration Act. Now, one of the important things to consider over here is that one of the important things to remember in this definition is whether the dispute is commercial under the laws and force of India or not. Now, this sounds like something which could be relatively simple, but it is actually quite complex. Now, as it happens, India believes that only commercial disputes can be settled by arbitration and not other disputes. And what is commercial is something which is defined differently in different countries. As we will come and we are going to discuss one of the cases which is recently involved in Singapore, which means a kind of confusion which can sometimes occur. Now, one of the important things over here is, again, you may be familiar with something called investment treaty arbitration. Now, what happens is because of foreign investments,
Sorry to
pardon me.
Sir, sorry to intervene in between. The slides are not moving and it is not full screen. So my request is, Zoya, if you can please put the relevant screen on this relevant slide on. Thank you.
Sorry, just 1 second. We'll start this again. Can you now see the screen completely?
Yes, sir. Screen is visible, but the slides are. It's not full screen.
Just 1 second. I will just do something about it. Just one
Yeah,
second.
sure.
My apologies for this technical interruption. But I could
Oh, no
let me
problem.
just continue
Sure, please.
the screens. Yeah. So what I was
Yes,
saying
sir.
was the important thing over here to remember, of course, is that the standard definition of international arbitration would basically mean when there is one Indian party and there is one foreign party, or of course two foreign parties, which may for whatever reason have a dispute which has a connection with India. But what is important over here is that there is also a requirement in Indian law that the dispute is basically commercial in nature. Now that is a slightly controversial topic because what is commercial in India, it's not necessarily what people would normally regard as commercial abroad. For example, in India, disputes which are in relation to shareholders, but particularly, for example, disputes which are in concerning something like operation and mismanagement, they are typically arbitrable in other countries, whereas they are not necessarily treated as arbitrable under Indian law, which basically implies that if the arbitration which takes place in a foreign country which concerns this, it might not necessarily be enforceable in India, which is actually the biggest problem. Another thing which is important to consider, and this is also one of the big issues in when it comes to investment treaty arbitration. Now there are again, this is in connection to foreign investments which take place in India or abroad. Like for example, India and Bangladesh have a treaty of have a bilateral investment treaty, which means that for example, because of recent trouble in Bangladesh, if there is some movement by the state either to increase the taxation on Indian parties or for example to take over investments in those countries, Indian parties can go under the benefit of the bilateral investment treaty and have an arbitration between the government of Bangladesh and the Indian party. Or similarly, of course, it could also work completely the other way. If that, for example, of course, we've had multiple treaties of multiple cases where, say, an Australian company or a British company or a Norwegian company have sued the Indian government under bilateral investment treaties. Now, the thing is that bilateral investment treaties, the issues are frequently in relation to public law, like, for example, taxation policy. So these are not commercial arbitrations for the purposes of Indian law, which means that they cannot be enforced in India under the Arbitration and Conciliation Act, which is the only system by which arbitration awards can be enforced in India. So the implication of this basically is that one has to always see that the subject matter of the arbitration is commercial, both by Indian law as well as by the foreign law. Otherwise, if you have a foreign award which deals with the commercial, which deals with an item which is not commercial as per Indian law, then the award will not be enforceable in India. Now, the Supreme Court has also clarified that two Indian parties can choose a foreign seat for their arbitration. This Yeah, I'm sorry again. I hope that you can see the slides now.
Yes, sir.
Yeah.
Slides are there.
Yeah. So earlier the situation was that two Indian parties cannot. There was some confusion whether two Indian parties can choose a foreign seated arbitration or not. But that has been clarified by the Supreme Court and the PASL judgment. So again, basically, we've talked about the whys and hows of international arbitration as to how it takes place. I would imagine that many of the parties over here, when they have international contracts, whether in connection with trade or with investment, they are faced with international arbitration as a dispute resolution clause. And that is also for another reason that for whatever reason, Indian dispute resolution clauses are not entirely popular abroad. So which means that people are scared that dispute resolution in India takes too long and it might be much faster abroad, which is, of course, I think it totally depends upon from case to case. But then this again is the reason why Indian parties are frequently faced with international arbitration when it comes to this. Also, for example, if there is it's again a matter of negotiation. But if, for example, there is one party from Japan and another party from India, typically they would choose a third party where arbitration would take place, so as to ensure that no party is at a particular advantage or disadvantage. Which is why many times, for example, people choose a seat like Singapore, which is very convenient both from the Indian and Japanese point of view, where there is some cultural familiarity and which is a popular destination. Similarly, when disputes are some jurisdictions have over a period of time developed a great deal of jurisprudence in particular areas. This could mean, for example, for maritime disputes, one of the best places is London. It remains London. Historically, it's been the seat because they have a very well settled system of maritime arbitration over there with extremely well established case law. So anyway, this was about the basics of international arbitration. Next slide, please. Now we can talk about what are the three main heads which I propose to discuss with you today. Again, I don't want to get into deep lawyer-like details because I know this is a gathering which is not meant for lawyers. But what we are going to broadly talk about is the role of the courts, the grounds for challenge of an award of arbitration, and the enforcement and execution of the award. Now, basically, what is arbitration? Arbitration is that instead of going to the courts, both parties which have a dispute which is under a contract go to private individuals who are empowered to decide the dispute according to the laws chosen by the parties in particular jurisdictions. Now, one of the how that works in terms of international arbitration normally is that, for example, the Indian party appoints one arbitrator, the foreign party appoints another arbitrator, and both of them together appoint a third arbitrator. Now, normally, if you go to the standard systems of institutional arbitration abroad, such as the ICC or the SIAC or the LCIA or any of the other established institutes, they have various mechanisms by which international arbitrators can be appointed. So frequently you can choose arbitrators and they choose the others, or if the dispute is of a smaller than a particular size, then there may be one arbitrator which is chosen by the institution itself. Now again, one of the standard rules, and this is true also in India, is that if, for example, to come back to our example, if it is a Japanese and an Indian party who have a dispute, then the arbitrator will not be from Japan or from India, but would be a third from a third party country, so as to ensure complete impartiality. Incidentally, also in India, you can go under section 11, subsection 12 to the Supreme Court of India in relation to an international arbitration for appointment of an arbitrator. slide, please. Over here, we come to the role of the courts. Now, the role of the courts is basically we looked at in terms of three things. One is referral to arbitration. Now, what happens many times is that initially when parties contract, they are quite keen to agree to an arbitration clause because that is the done thing. But when it actually comes down to a dispute, one party for whatever reason may decide to go to the courts instead. So there is section 8 in the Arbitration Act for domestic arbitration and 45 for international arbitration. Whereas if the parties go for this, then the courts will refer them to arbitration. Again, like I was mentioning earlier, the second point about appointment of arbitrator, the international commercial arbitration appointments are done by the Supreme Court of India. Usually, it's the Chief Justice who appoints who appoint international arbitrators under Section 11 subsection 12 of the thing. Again, like I said, like the same principle which applies in the SIAC and the ICC, etc. If there is one arbitrator who is chosen to resolve the disputes, he belongs to neither of the two countries, but belongs to a third country. A third thing to look at is interim relief. Now, again, what happens many times is that when parties go into arbitration, you want to protect, and this is again, of course, when parties also go for disputes, they want to protect their interests beforehand to make sure that the party does not flit away all of its assets. So for Indian law, for Indian seated arbitration and for Indian arbitration, it's relatively simple. You go under Section 9 of the Arbitration Act and ask for an interim order, and then you go for the to protect the assets from being dissipated, and then you go to the arbitrator to continue that. You also have the option to go to the arbitrator after he has been appointed to take interim relief, which means some kind of stay. Now, what happens in international arbitration is a little more confusing. Now, normally, there is no provision in the Arbitration Act which provides for interim relief for foreign arbitrations. That's mainly because if they are seated abroad, then you would typically go to the courts of the place where the arbitration is seated. And secondly, you would also go to the institution which frequently provide for something called emergency arbitrations to provide for interim measures. So what the Indian courts have done over multiple cases is that they have developed normally in India, once an arbitrator is appointed, then the courts no longer have the power to grant interim relief. You go to the arbitrator under Section 17. In cases of international arbitration, where the arbitration is seated outside the country, various high courts of Delhi, Bombay, and other places have considered that there is no efficacious remedy to get a stay for international arbitration. Therefore, it is necessary for the parties to, if they obtain an order from an arbitrator, to file an application under Section 9, same as a domestic arbitration, and get the same award. So this is a good way by which Indian courts have innovated and can still grant interim relief in terms of international arbitration. A second and more important thing is something called anti-arbitral injunctions. Now, what happens is this: many times Indian parties feel that the arbitration process is not going in a way which favors them. This may be for a variety of reasons, which may be correct or may be incorrect. But whatever it is, there is a mechanism by which the courts in India can grant an injunction, stopping the parties from going ahead with the arbitration. Now, normally, of course, this would take place in the jurisdiction where the arbitration is taking place. But Indian courts have also exercised this jurisdiction, and I will give you two cases which we will casually mention over here, although we can get into a little bit of a greater detail later on. The first case is Anupam Mittal versus People Interactive. I will get into this. I'm using this case a little later in the presentation as a kind of case study of what could possibly go wrong or go right from one's perspective in international commercial arbitration. Here, because of if you recall what I was discussing on the last slide, was the issue of whether an arbitration is whether the issue is commercial or not and can be settled by arbitration. Now, in this particular case, there was a shareholder dispute relating to operation and mismanagement, which, according to the Indian courts, goes to the NCLT. Therefore, in India, such a dispute is not arbitrable. Whereas this dispute is being resolved in the Singapore Court of International Arbitration, where such a dispute is arbitrable. Therefore, the Indian courts, the NCLT, eventually granted an injunction to Anupam Mittal, because on the ground that any award which is got in this case from the Singapore Court of Arbitration would not be enforceable in India because it is not arbitrable. So one of the grounds for granting an injunction could be that the dispute is not arbitrable in India. So what is the point of going forward with something which you cannot enforce? A second, this is again, like I said, complicated and controversial, because what is arbitrable and what is not arbitrable, there is no clear list which is provided anywhere. The real truth is that Indian courts generally hold that uh, proceedings in rem, which means that proceedings which go beyond two parties, cannot be arbitrable. So obviously, for that matter, say family disputes, a matrimonial dispute cannot go into arbitration. Similarly, if like I said, in terms of international bilateral investment treaty arbitration, many disputes related to the country's taxation policy are not commercial disputes as per Indian law, and therefore they cannot be arbitrable. Therefore, the Indian courts could theoretically grant an injunction. Now, in TechFab International versus Midima Holdings, the Delhi High Court recently granted an injunction basis the fact that the arbitral tribunal was not constituted as per the agreement. This again, to my mind, is a relatively cleaner example, because the arbitration clause is visible for everybody to see, and that has to be followed. Normally, an arbitrator, as is well known, is a creature of the contract, which means that he has to strictly go as per the contract. And since arbitration provides jurisdiction basis the agreement of the parties, the agreement of the parties as regards the constitution of an arbitration tribunal is extremely important. Now, in TechFab, it appears that the arbitral tribunal was not as per what the contract provided, and therefore the Delhi High Court did grant an anti-arbitral injunction. So again, when it comes to interim relief and when it comes to anti-arbitral injunctions, Indian courts have taken a fairly interesting view and tried to come around the statutory difficulties and help people wherever they can. Again, this is true generally for arbitration as well. Indian courts have tried to improve the general earlier reputation of lethargy by going on and acting in a proactive manner so as to support parties and to ensure that the arbitral process carries on forward in a good and in a complete way. This is both in terms of referring parties to arbitration when there is an arbitration clause. This is also in connection to the appointment of an arbitrator under Section 11 of the Arbitration Act, as well as the grant of interim relief and for the grant of anti-arbitral injunctions in appropriate cases. Now, one more issue which I want to discuss quickly before we move on to the main meat of the presentation is about emergency awards. And this again is sort of familiar these days because of the dispute between Amazon and Future Retail, which was a massive dispute in India and which has been talked about extensively, particularly by arbitration lawyers, but I think also generally in the commercial sense. Now, what many arbitral tribunals and institutions, both in India and abroad, provide for is something called emergency award. This basically means normally what happens is that if you want interim relief, like I said, before an arbitrator is appointed, you go to the court under Section 9 of the Indian Arbitration Act, get that relief. Or you go after the arbitrator is appointed, you go under Section 17 of the Act to get relief from the arbitrator. Now, what many institutions do is that if there is something which you want urgently, whether it's in terms of interim relief, etc., you go to a process called emergency award, which means that the arbitrator decides extremely quickly, and you have an award within 15 days or 30 days or whatever period. It's actually a very convenient mechanism by which parties can have their issues resolved very quickly. Although obviously this means that you won't have that much time to prepare the pleadings or the evidence. It moves very quickly. The advantage of that, of course, it's very quick, and that's why you choose it for particular things. Now, what happened is that when our Arbitration Act was amended, and in 2015 it was amended in very significant ways. There was a proposal to introduce the concept of an emergency award, but that for whatever reason was not included in the parliament. So now the question arises: how would the Indian courts deal with emergency awards which take place abroad? Now again, in the Amazon Future dispute, there was a emergency award which was passed by the SIAC, the Singapore International Arbitration Center, and the question was enforcement in India. Now the single judge of the Delhi High Court decided to enforce it. The division bench of the High Court, when it went up in appeal, did not enforce it. Eventually, the Supreme Court said that when you choose an institution like the SIAC or the LCIA or any other institution, if that institution provides for emergency arbitration, you have agreed to it, and therefore it is enforceable as an award under Indian law. So this again was an innovation of the Indian courts, because the Arbitration Act does not provide for for emergency things. But it's a useful, very useful mechanism because this enables parties to choose this. Again, the main thing about arbitration is that it is about the choice of the parties. Both parties choose this mechanism for a variety of reasons over the courts. This could be in terms of time, this could be in terms of flexibility of procedure, or this could simply be because that a court proceeding might irreparably damage the relation between the parties, whereas an arbitration, which is a slightly more informal mechanism, may be actually better. So therefore, emergency awards are a very useful tool as well when the quick answer is needed. Again, we have discussed, I've talked about the Amazon future case a little bit on this slide. So we basically say that the Delhi High Court issued an order by which it held that the emergency arbitrator should be recognized as the arbitrator, and the interim award would be enforceable under Section 17 of the Arbitration Act. Therefore, after that, it went in appeal to the division bench, which granted a stay of the judgment, which means that the award was not enforceable. The Supreme Court then, an SLP was filed against that by Amazon, and the Supreme Court passed a final judgment and holding that the Arbitration Act does not prevent commercial parties from agreeing to procedural rules that allow an emergency arbitrator to grant interim relief. Therefore, again, like I said, you can say that the Arbitration Act and the courts act as facilitators to what parties already want and what they decide. And one of the good things or bad things, as your perspective may be, to choose rules such as the SIAC or the LCIA is that they do have rules for this kind of thing to ensure that things are done which are done relatively quickly. Thus, an emergency arbitrator's award can be enforced under Section 17(2) if the institution so allows. The court emphasized that parties have the autonomy to choose institutional rules that govern their arbitration proceedings. Now, next we can come to the case which I was talking about, that is Anupam Mittal. And this again goes on to show one of the problematic aspects of international arbitration, again arising from what I discussed on the first slide with relation to whether the dispute is commercial and whether it can be arbitrable in India or not. Now, in this case, again, we have in this slide we have done a little bit of a factual narration, which is not completely relevant. What I would just say for your purposes at this time is that a shareholder agreement was signed in relation to for a company which was to operate inside India. Now, this shareholder agreement provided for an arbitration between the parties in case of any disputes arising. But what happened was that Mr. Mittal filed a case that an anti-enforcement suit in the Bombay High Court when the parties were going to SIAC, saying that the only competent authority to decide the issue of operation mismanagement was the NCLT. Therefore, what happened in this case was that again the judicial mechanism of both countries, Singapore and India, was involved in this. When Anupam Mittal filed this anti-enforcement suit in the Bombay High Court, Westridge filed a similar anti-suit injunction against Mittal from the Singapore High Court, saying that Mr. Mittal should not be allowed to go to the courts of India. Now that was granted by the Singapore court, saying that since the disputes are to be resolved by under the SIAC and Singapore, Mr. Mittal cannot go to the Indian courts and get that relief. So Mr. Mittal then files a petition before NCLT saying that how can I be stopped as an Indian party from going to the courts in India? Basically, the Singapore High Court passed a permanent injunction against Mr. Mittal from pursuing any remedy in India. This was again challenged by him before the Singapore Court of Appeals, and the ICC Court of Arbitration issued a partial award to Westridge, that is the other side, without prejudice to Mittal's right to raise any jurisdictional issues. The Singapore Court of Appeals again upheld this injunction, and Westridge invoked arbitration under the ICC tribunal. The Bombay High Court now in the meantime granted relief to Mr. Mittal, saying that the Singapore courts could not have granted such an injunction. And secondly, then eventually goes on to decide that since in India a dispute relating to operation mismanagement is a dispute which is not arbitrable, therefore arbitration cannot take place. Now this case is a good example, and again I apologize for being extremely brief about the fact of this case because I don't want to get into unnecessary details. But the reason why I wanted to bring this to your notice is that this is a potential fallback, a potential thing to watch out for international arbitration, because this is something which could easily happen, that the parties somehow fall in between the gaps between the systems of two particular countries. Now, as it happens, operation mismanagement disputes are arbitrable in Singapore, they are not arbitrable in India. Again, what is the relationship between the Indian courts and the Singapore courts is one of comity of the courts. Courts recognize each other and they give respect to each other, but that is not always the case because their primary issue remains respect to their own laws. So in this case, both the Indian and the Singapore courts went their own way. The arbitration is going its own way, and the NCLT will decide on its own. So eventually, when this dispute is finally decided, there will be a complete, for lack of a better word, a mess as to how the issue eventually gets resolved. This leads to a great deal of unpredictability in commercial disputes. And again, the potential, like it happened in this particular case, of conflicting injunctions from different courts. And again, the difficulty in the larger issue is the difficulty in balancing party autonomy on one side and public policy considerations, where such as what is arbitrable or not, on the other side. Now, I wanted to point this out as an example, as a precautionary tale, but this is not necessarily the case in most arbitrations. Again, international and commercial arbitration could be seated in India or it could be seated abroad. Most arbitrations do not raise issues of this particular nature. But again, I think particularly when it comes to issues like shareholder disputes in a country, in a company or which is based in India, it might not necessarily be prudent to have an international arbitration clause over there because again, in India, NCLT disputes are not arbitrable. Again, this is an India only problem because if, for example, the company was based somewhere else, if this was a Singapore-based company, there would be or a UK-based company, there would be no objection to this issue being resolved by arbitrators. Next, we come to foreign awards and how to enforce them. Again, what I have discussed with you so far has been what is an international commercial arbitration, how the courts assist in that, and maybe I can talk a little bit before we start foreign awards on the process of international arbitration. Now, the International Bar Association has various guidelines on issues like evidence, how evidence is to be led, and how it takes place in international arbitration. And there is always constant innovation by various tribunals as well. For example, the ICC in its system has something which is called a TOR, which is terms of reference. When an arbitrator is appointed, when an arbitral tribunal is constituted, then they first decide on the terms of reference, which basically look at the disputes, they settle the issues which are to be decided upfront, and what is the process which is required to be followed by the parties. In India, where a lot of arbitration is ad hoc arbitration, this does not take place initially. Like in matters where I sit as arbitrator, for example, I have tried many times to lay down a timetable which parties follow from the start, but that is not always the experience in India. If you are able to follow the ICC and other institutions, you follow their rules, the timetable or the schedule is settled years in advance, which basically means that parties are able to ensure that they block those particular dates and the arbitration can carry on, proceed firmly in that regard. And again, one of the important things to consider is how evidence is dealt with. And I think the biggest difference between Indian arbitrations and foreign arbitration is how they deal with something which is called discovery. Now, if there is a dispute between two parties, both parties put forward their evidence in the form of affidavits or they have witnesses. But many times it might happen that that one party does not have all the information which it requires because the other party has access to it. What they can do both in Indian law, although it doesn't happen often, and of course in foreign arbitration, is to file an application for discovery, which means you ask the other side to produce those particular documents. Now, the International Bar Association, and its guidelines based on how the arbitrators are supposed to deal with this. There is something, for example, called a red fern schedule, where the parties mention what it is that they want from the other party, and the arbitrators have to decide whether that demand is reasonable or not, whether it's excessive, whether it's going to put too much damage, and whether there is any value to that or not. Now, for example, if the dispute between the parties concerns documentation which goes back 15 years, and your demand for in discovery and a discovery application is give me every single thing decided between the party for 15 years, then the arbitral tribunal might rule that this is an unreasonable request, that you want to make your demands more specific, that okay, in relation to this particular project or in this particular time period. So you can demand from the other side, and they are obligated to give you whatever the arbitrator or the arbitral tribunal decides. And this is a very useful way to go forward in things. Again, of course, the fact always remains both in Indian and international arbitration. If you are not able to put forward evidence, then or if the party is asked to produce evidence for the other side and they fail to put that forward, then that will probably be used against you by the arbitrator while deciding the thing. Again, when it comes to another important distinction, which I think is useful, is the use of expert evidence. Frequently, we are concerned with matters of complicated matters of construction law, complicated issues of company law, complicated issues relating to all manner of maritime issues or any kind of thing. What you need, in particularly in relation to damages, we have these days experts, which are there are a great deal. There are many companies which offer expert services. There are a great deal of experts who are recognized by all over the world, who are able to put this forward. Particularly, say in an issue like construction arbitration, in order to prove what exactly has gone wrong, who has caused the delay, which is usually the case in construction arbitration, they're arising out of delay, or how much is the damage caused because of the delay. For that, you engage an expert who engages with the tribunal and whose report the tribunal uses in order to come to an award to decide whether there are damages which should be given or not given. Again, expert evidence is frequently recognized in Indian law as well, and I think it's become more standard in construction arbitration, particularly in all large engineering contracts as well. It's something which we advise our clients these days as well to go ahead for, and this is also something which they must get used to in international arbitrations. This is therefore it is not merely what lawyers say that I have suffered this loss or that loss. It has to be properly explained and brought forward, which is an important thing for parties to do when they hope to obtain an award in their favor. Again, so this was the process of arbitration. Now, one of the great things about international arbitration is that, particularly if you go to the ICC or if you go to SIAC, is that they have a full court reference, which actually kind of, you can say, checks the arbitration award before it's published. Unlike ad hoc arbitration in India, where the arbitrator signs something and that is the end of the matter. Now I want to put this very carefully, because of course one of the main things of arbitration, the first thing is party autonomy, second thing is confidentiality, which basically means that the what is decided in arbitration frequently is confidential. It is not meant to be reported like judgments are reported, which is why you will not find arbitral awards being published in most cases. Although now there are some publications which are putting forward arbitration awards. Again, they don't really have much precedential value. A judgment by a court has precedential value, which means you can cite it again. But an arbitration award does not have any such value. In fact, recently there was in the Singapore courts, they have set aside one award where the arbitrator, this is an India related arbitration, the arbitrator cut copy paste the first award, put it in the second award, and the court felt that this was a violation of natural justice and this could not be done. This again proves two things. One is that the standards for looking at evaluating awards, both at the institutional level, both like say for example, the ICC or the SIAC, they look at awards, they scrutinize awards carefully to ensure that basic errors are avoided and that the reasoning of the award is sound. The person deciding the dispute remains the arbitrator, and the confidentiality rules of these institutions permit the ICC court to look at at least some basic stuff. Although again the details can be confidential, but the award which comes out of such a process, typically the ICC or the SIAC or LCIA, is usually in a much better condition to be enforced than it would be otherwise. Not to say that Indian ad hoc awards are in any case bad or they have to be looked at, but an additional layer of scrutiny also is a useful thing. Again, what is important to consider always is for when depending on what kind of tribunal a party should choose, is convenience of parties, the convenience of the tribunal, the enforceability of the award which comes from their costs, and issues like whether there is scrutiny or not. I think based on these factors, a lot of Indian parties these days go to Singapore for disputes. Like I said, particularly in pan-Asian disputes. Traditionally, they have also gone to London, which was formerly a massive hub for Indian arbitration. And in fact, you might observe when you read judgments which are reported in Lloyd's reporters, which is the commercial law reports, a lot of them seem to be arising from Indian facts. Another frequent place where people go to is Stockholm, which is another thing. And this again it makes you wonder really, because there are two essential kind of legal systems that are in this world. There's a common law system that is the system which is followed by India, the UK, to some extent the US, Australia, and the members of the Commonwealth. And there is a civil law system which are other countries like Japan or China or France or other countries. And civil lawyers and common lawyers look at things in a very different way. A civil law centered jurisdiction is far more arbitrator heavy, whereas common law lawyers are used for lawyers to prove their case and the arbitral tribunal to essentially sit like an umpire. Civil law judges civil law judges and arbitrators are much more involved in the process. Therefore, one of the great things of something like ICC is that it enables common law and civil law lawyers to work together, which is also and therefore there's familiarity with both systems. Again, these are the kind of things which you have to think about in international arbitration, because when we arbitrate or when we litigate in India, we are used to all Indian lawyers will be looking at things in a particular way. So will Indian clients, obviously. But when you interact with people from a different country, particularly a civil law country, like say for example Japan, they have a very different way of operating, both in terms of putting forward their case, both in terms of arguments, and how the arbitrators will decide. Again, these are all factors which are important to look at the process. Now we come to what happens at the end of the process. At the end of every arbitration, you get an award. Either party A wins or party B wins, or maybe both parties get something or the other. So how do we deal with an arbitration award which has come in an international arbitration? Now, a foreign award is defined in Part 2 of the Arbitration Act as an arbitral award realizing a commercial under the which is commercial under the laws of India. Like I said, commerciality is basically what it is. Made after the 11th day of October 1960, that is in relation to the New York Convention. In pursuant to an agreement in writing for arbitration, because arbitration agreements are required to be in writing, and in a country which is a reciprocating territory as per the CPC, or which is a signatory of the New York Convention or a Geneva Convention. And what is important is, again, and this is a slightly procedural requirement in India, is that the a notification of Government of India should say that it is the New York Convention or a Geneva Convention. Now, as a matter of practice, most countries, and certainly most countries where you are likely to have arbitrations, are members of the New York Convention or Geneva Convention. This basically implies that there is a large variety of variety of jurisdictions where awards could easily be passed with art which are recognized in India, which could be enforced in India for a variety of ways. The real issue comes that the Indian again, this is a requirement that the Indian government is supposed to recognize that this country is a signatory. So this should typically imply that the Indian government should take out the list every year or something. That these are the parties who have now signed down to the New York Convention, Geneva Convention. It may happen that there is a country which has signed, so therefore which is New York member, but because Indian government has not notified that in the official gazette, it is not recognized as a reciprocating territory, and therefore it does not apply. Anyway, hopefully this is not a problem which any of you should encounter. But I have to say that when we deal with non-reciprocating territories, which are not territories which are covered by the New York Convention or the Geneva Convention, we do face some difficulty in the courts because the process which is there for enforcement is under the CPC, and this is a very archaic and old procedure. Now, we are currently in our firm, we are dealing with the enforcement of a judgment which was passed by the Supreme Court of Macedonia. Again, jokes is it's not a country which Indian courts are intimately familiar with, and we are facing it's been unusual for us to explain to the courts as to how this takes place. Now, one of the great advantages, like I said, of international arbitration is because of the existence of conventions like New York Convention, Geneva Convention, to which most countries are parties. Most awards, and particularly in standard places like Singapore or London, are recognized, and they are recognized, they are enforceable. One issue which we could possibly face over here could be that of Hong Kong. Now, Hong Kong, of course, was a signatory as well, and say Hong Kong also has a very good arbitration setup and a good court system as well. But Indian parties, of course, feel that Hong Kong is maybe more influenced towards China, which is the reason why there is not so much arbitration there. And there may also be an issue with enforcing Hong Kong awards sometimes, because if China is a party or Hong Kong is a separate party, that's also something to be considered. Now, again, to the next slide, we will talk about quickly about the process under the New York and Geneva Conventions. This is dealt with in the Arbitration Act under Section 47 for the New York Convention, and under Geneva Convention Section 56. Just see what is the requirement. An original copy of the award, duly authenticated in the country, whatever is the mechanism of that country, the original agreement of arbitration, and such evidence to prove that the award is foreign award and will become final. Similarly, in Geneva, so under the Geneva Convention, you require a copy of the award and evidence to prove that has become final. Again, it is so much simpler to do this. If you don't have, if it is a country which is not covered under New York or Geneva Conventions, then you have to basically prove the case all over again, which is a much more complicated and difficult mechanism. To execute now what happens is an arbitral award recognized under the New York or Geneva Convention is enforceable as a decree of the court is enforceable under Order 21 of the CPC, which contains which contains the procedure. The section Order 21 contains all manner of rules, the 106 rules, and which I'm not, again, we don't want to get into such great detail right now. But execution can be filed in any place. Now, typically, what Indian parties or foreign parties would like to do is to enforce in the place where the assets of the company are located. If you have an award against an Indian party which is located, say, in Rajasthan, then you will file enforcement in Rajasthan. If the company has assets in Rajasthan and in Kerala, then you might consider filing in both places. Or you file in one place and put that in the other. The jurisdiction of the, basically, wherever the assets of the company are located, it can be a valid jurisdiction for you to execute the award. Again, when it comes to a reciprocating international arbitration with seat in a reciprocating territory, again, we are talking now about countries which are not covered by the Geneva New York Conventions and the reciprocating territory. So again, I don't really want to focus on this too much because there aren't very many countries which are left which are in cell. But in the post the 2015 amendment, Part 1 of the Arbitration Act will not apply to foreign seated arbitrations except Section 9, 27, and 37, which is the 9 is for interim relief and 27 and 37 are yes. The Arbitration Act is 2015 Amendment Act is prospective operation, which is from October 25, 2015. Now we come to one of the interesting things again when it comes to that. We've talked about enforcement and recognition of foreign awards. Now we talk about challenges to foreign awards. Now, foreign awards can be challenged in India on a variety of grounds. These are grounds which are contained in domestic arbitration in Section 34 and in foreign arbitrations in Section 46. In Section 48, I'm sorry, Section 48 of the arbitration. Now, these are grounds we have. We don't need to discuss what was the law prior to the 2015 Act, but we can look at the post 2015 and post the 2021 amendments. We can see what are the awards. Basically, in the public, basically the grounds for challenging an international arbitration award are rather few. They are similar to what are the grounds which are contained in Section 34, except that patent illegality, which is the ground for setting aside a domestic award, is not available for international awards, and the ground for which is called public policy is much more narrowly construed for international arbitration than it is for domestic arbitration. Now, let me tell you how this works. One of the main bugbears of Indian arbitration for a long time was a very expansive definition which was given to public policy. This was for domestic awards, and by similar logic, it used to apply to international awards as well. This was something which the legislature was very conscious of when they made changes to the law in 2015. So the grounds upon which a foreign award can be challenged on ground of public policy have been made much rarer and more difficult than domestic awards. In fact, there was a recent judgment in the Delhi High Court called Mercator versus Dredging, which looks at the law on this fairly comprehensively and which gives a complete detail as to what gets covered by public policy, what is not. Now, for example, if an award like in the dredging case which I was talking about, the award they said was in violation of the Merchant Shipping Act. Now, the Merchant Shipping Act is a law in India, but it is not necessarily but violation of this law would not be a violation of international public policy to set aside an international award. It would be slightly different, perhaps, in the case of a domestic award, where patent illegality is a ground for setting aside a challenge. But public policy, like I said, for international awards, has been given a far more narrow interpretation. Now, what would be classified as a ground for setting aside a foreign award could be if the award is procured by corruption or if there is a fraud, which are standard grounds everywhere. But otherwise, the courts will not go into the entire issue all over again and set aside because they think that the arbitrator has got the wrong law. Again, we come to some important cases which we can talk about casually. Of course, we discussed Anupa Mittal, which is one of the most important ongoing cases on this. And we've talked a little bit about the other challenges as well. In Bharat Aluminium versus Kaiser, by Supreme Court, they said that Part 1 applies to Indian arbitrations or domestic seated international arbitration. Which means when the international arbitration is taking place in India. Again, international arbitration means where it's seated abroad or it's seated in India, as long as one of the parties is a foreigner. Second, there is Sri Lal Mahal versus Progetto Grano, which again deals with public policy. Like I said, Progetto and other decisions have been, and Vijay Kariya, which is also discussed over here, have been recently looked at by the Delhi High Court in this judgment called Mercador versus Dredging, which covers the ground, I think, completely. TSL Wind talks about whether two Indian parties can sue the foreign arbitration as well, which is completely the case. And Noy Valencia deals with the reiterating Balgo principles and said that a foreign seated award cannot be challenged under Section 64. It has to be challenged only on ground under Section 48 and 57 of the arbitration. Again, we come on to the next slide, which deals with the list of renowned international dispute resolution institutions. Again, like I said, there are many factors to consider which international tribunal to choose. The ICC is a very good option. The LCIA is a good option. The SIAC is a good option. The Permanent Court of Arbitration exists as well, which is a good option. The Stockholm Chamber of Commerce is frequently chosen. We have also two recent centers, which are the Dubai International Arbitration Center and the Saudi Center for Commercial Arbitration. The Dubai Center has already developed a very good reputation for construction disputes. Although we are parties are still looking at and that we have to see how long over a period of time how this institution develops. But particularly London is a very old established institution, so is Stockholm. And ICC, of course, is also more than 100 years old and extremely well known. And these are institutions which have very good rules, which are applicable to all parties. Indian courts have frequently recognized their awards, and there should be no particular difficulty. There is a great deal of familiarity in India with Singapore International Arbitration Center as well. A lot of our bar is qualified to practice in Singapore, and they do practice in Singapore. And we frequently find Singapore arbitration awards which are either enforced in India or Indian parties which are using them abroad. Again, the Indian institutes where international commercial arbitrations are carried out they could be the Mumbai Center for International Arbitration, the MCIA, the DIAC, which is the Delhi International Arbitration Center, the BCCI in Bombay, and the Indian Council of Arbitration, which incidentally does a great deal of maritime arbitration. Emerging trends. What are the large emerging trends in international arbitration? Again, the first and most important is the increased use of technology. The world of arbitration was basically pushed into use of technology like everybody else because of COVID and Zoom. Like we have this wonderful seminar based on Zoom. So there is a great deal of innovation with regard to virtual hearings and with regard to e-filings. So therefore, the filing 15 copies, they're getting various copies, getting them photocopied according to particular formats. A lot of that is a thing of the past. Now most filings are e-filings. Most hearings are virtual hearings, except when actually required. For many Indian parties, they tend to insist on physical hearings when it comes to evidence for cross-examination. But then again, cross-examination may not be necessary in every case. But where there are witnesses, sometimes parties prefer cross-examination. Although again, many institutions and many tribunals choose to have even cross-examination done virtually. And final arguments, again, parties can choose or not choose whether to have them or not, depending on considerations of cost or convenience. Specialization in arbitration. This again is again how the process develops. Lawyers, say 40 or 50 or 60 years ago, would be generalists like doctors could be generalists as well, I suppose. But now there's an increasing specialization, particularly also in terms of arbitrators, in terms of practitioners, and in terms of institutions. Like I said, Dubai is becoming an increasingly good arbitration center, which is known for its construction work. London remains one of the great centers for maritime arbitration. And sector-specific expertise is extremely important because this is how the law evolves and develops. International cooperation. There's a great deal, the ties between institutions and between countries is rising. For example, the SIAC was here, I think, about 2 weeks back for a roadshow presenting what they have to go forward. The ICC also frequently has frequent seminars and sessions over here. And I would encourage all of you to attend some of them to see if they could be useful for you. shift towards institutional arbitration, which is again extremely important both in India and abroad. Ad hoc arbitration has worked relatively well for a long time, but many of the problems of Indian arbitration are frequently problems of ad hoc arbitration and not institutional arbitration. It is ad hoc arbitration which gets delayed frequently, where there is no fixed mechanism. Institutional arbitration has cures for many things, and the way the arbitration takes place is usually in a much more efficient way. Data protection and cyber security. Of course, this is a challenge for all companies as well, and particularly for arbitration processes, particularly in relation to confidentiality. Well, thank you very much. This was a presentation. I'm very grateful to my friend and colleague Zoya for putting this together. Zoya and Gyanendra who put this together, and Zoya who shared this presentation with you. I'll be happy to address any questions which any of you may have.
Yeah, thank you, sir. Thank you so much. We are really grateful to you for such a comprehensive presentation and for so much information on this very important topic, which I think many companies were interested, and they must have got a lot of information from this session. So we have requested members to post their question in the Q&A box, and I am getting one message. Q&A box. I don't know if members are want to ask directly. If they want to ask any question due to the confidential reasons and all, they can directly write to Rahulji, or they can send me the question and we can forward to him. So that way we can do.
Here,
we have one question and
yeah, we have two questions.
Yes, sir.
I can ask one, which answer one, which is by Advocate Ashok Shingare. Just for my knowledge, how would you allow a third party if he or she is biased? Now, the thing is that in the Indian Arbitration Act, we have Section 12, Subclause 5, and the list who can be arbitrator, who cannot be arbitrator, and who is not supposed to be an arbitrator. Now, this actually is based on the International Bar, the IBA rules. In international arbitration, it is very certain that you cannot be a biased. There's a very strong rule and determination against bias, which is the reason why in international disputes, for example, if there's a dispute between an Indian party and a Japanese party, then an arbitrator, if there's one arbitrator to be chosen, he'll be neither Indian nor Japanese, but from a third country. So again, for the issue is that the parties should choose a neutral arbitration venue and a neutral arbitrator. But if you go to an institution, they will make sure that there is neutrality. Every person who acts as an arbitrator is required to fill in a form disclosing a conflict of interest which he or she may have. For example, if I am appointed as an arbitrator for a particular thing, the first thing which I do is write to the parties informing them that I have no bias in this matter, or I have acted for this party in the past, or my firm has represented this party in the past. But it's a very standard thing. I think that if there is bias which is found, then it's quite a bad thing. There are some recent UK Supreme Court judgments on this also. I don't want to get into it in any great detail, but nonetheless, I can only add that bias is a very important thing. Third, a second question by Harita ji is whether Indian advocates can be international arbitrators. Yes, they can, and they are. There are many Indians who act as international arbitrators. I have acted as an arbitrator as well. It depends upon the process of appointment. You can be appointed by an institution, or you can be chosen by the party, as the case may be. In fact, recently the Supreme Court went and appoints arbitrators, frequently appoints Indian advocates as arbitrators as well. Then there's a question in relation for arbitration in Australia. Which center would you suggest commercial agreement between Indian and Australian company? Now, again, what I would do in such a circumstance is that I would consider if a third party like Singapore might be a good option, because it's neither Indian nor Australian. Neither party has an advantage of a home thing. If it comes to looking for a particular thing for Australia, to be honest, I don't have any personal experience from Australian institutions, but I can certainly check this and get back to you which are institutions which are there. But again, most countries do have arbitration centers which are relatively good and forward. Again, Australia is also a common law country like India, so it should not be very very difficult to pursue an arbitration over there. Again, what is the role of consulates in arbitration? By consulates, I would imagine you mean embassies and diplomatic consulates. I don't think that they have any particular role to play either which way. See, international arbitration is typically between two commercial parties. If there is a state party involved, for example, there may be a public sector company which we have a contract, it's still between two parties only. In fact, if you look at the tenders of government companies like STC or IOC, they have a term saying that this is for this party, not for government of India. You cannot do an arbitration against government of India if you want to go against IOC or STC. A second thing could also be that when it comes to treaty arbitration, like if India and Australia have signed a treaty, and there's an arbitration which rises from that, then there is a role of a state. But again, there is no role for the consulate. I think except maybe getting things notarized or something. Vijay Kanti, thank you very much. I'm glad that you liked the presentation. What should be broadly considered while drafting a standard arbitration clause or cross-border agreement? That's actually a very good question, and I think there are multiple things to look at this. One of the things which I have noticed as a disputes lawyer is that when parties enter into a contract, they have a different view, and when they have a dispute, they actually have a different view. One of the reasons, when you enter into a contract, you want a system which is quick, which is efficient, which you decide quickly. Whereas when it comes to an actual dispute, parties frequently want delays because they are worried about what might happen, or they're trying to negotiate with the other party and they want to put pressure. There are all kind of issues like that. So that is the first thing. A second thing which I would say is that you can never have perfection. Every system has its own pluses and minuses, which is why it's important to consider what is important. I would imagine that one, if it's an international agreement, typically try not to go to the one of the two countries where it's at. Like for example, in the early Australia example, I would ideally not want India or Australia over here. I mean, India, of course, it's my country, so I would want India for an Indian party. But if you are acting for an Indian party with a foreign party, maybe choose a third party if that's a feasible option. Sometimes it may not be because of financial reasons. That's a different point. The second thing is it should be a country which is a signatory to the New York Convention or Geneva Convention, so that the award can be enforced over here or wherever else. New York Convention awards can be enforced all over the world in most countries. So please, it's good to have an arbitration in such a country. Third is when it comes to language and availability of arbitrators. Again, when it comes to issues like, say, for example, maritime, Singapore and London both have excellent maritime arbitrators. Similarly, I mean, earlier I would also say Hong Kong, although now Hong Kong is a slightly different thing. There are multiple countries with excellent lawyers and arbitrators, and they have good reputations for it. It's useful to consider that as well. A fourth thing, of course, is costs. It may be very expensive for an Indian party to choose an arbitration in a place which is difficult or remote to reach at. So take, for example, if you want to conduct an arbitration in New York, whereas you are based in New Delhi. So if the arbitration is taking place in that particular country, you have to go there, you have to engage counsel over there, you have to be familiar with the systems. A fifth point would be the legal system, which is why I say that for us as Indians, as Indian lawyers, we are familiar with the common law systems. So these are good things for us. Both Singapore and the UK, for example, have excellent systems of this nature. And there is also a great deal of familiarity now with Dubai as well. That's another choice. And a final choice, of course, would be language. Choose a place where they use a common language, which will nearly always be English. And again, you look at the jurisdiction and see whether they have any particular requirements. Like sometimes we notice that again, this is not meant to be a criticism, but sometimes countries like Indonesia or Vietnam have unusual requirements for arbitration, to enforce arbitration awards. You might want to go to a country which does not have such requirements, or if you have such requirements, to make sure they're all covered. A good arbitration clause, in my view, would probably involve an institution where you can go, and which would be a one-stop shop for all kind of things, whether an emergency or an emergency award, whether choosing the arbitrator or making sure the process is smooth. So I think that would be something good to consider if when it comes to that. Any further questions? We are of course happy to share this presentation, and we can, like I said, please feel free to contact us if we can answer any further questions for you. If a foreign party to a contract is absconding and not responding, how do we initiate proceedings, especially in a money suit? It depends upon where the thing is. If the contract is, for example, concerning an Indian arbitration, then you go to Supreme Court and file a petition for under Section 11, subsection 12. If it's a foreign arbitration, then you have to follow the process which is set under that jurisdiction. We have a question also by Umesh, who's a law student. In the context of Arif Azim versus Aptech, wherein Justice Pardiwala pointed out the lacuna in NC Act regarding statute amendment on 11.6, the court merely pointed out a vacuum, did not read a specific time period. Do you think it's high time the court will say? But see, Umesh, firstly, this is not really a question for international arbitration, but I would say that you have to look at multiple things. Courts are when courts act, they act under the aegis of a statute. The people who are supposed to make the statute is the legislature. That is the democratic system. Courts have to look at the law and interpret it in a particular way. Frequently, they can provide answers to questions which are not completely answered by the statute. But when it comes to actually laying down of the law, it is not something for the courts. So they can identify lacuna. The lacuna have to be filled in by the legislatures, and this is something for the law commission to consider. This is something for lawyers. Maybe it is something which the Indo-American Chambers of Commerce can take up with the government and propose amendments. They keep amending the arbitration law. They've amended it recently in 2021 as well.
I think